Petition, society matter, election matter. Whether single judge has erroneously passed an order without assigning reasons, where for the including applicant, our application was not decided at all. In the letter, single judge has passed a final order. Based upon that, the election officer on 21st April has passed a notification for counting of the votes minutes, which is on 28/4 minutes. Hence, there is urgency. The petitioners who had won the case before the single judge were all disqualified members minutes without assigning any reasons. They were all disqualified. Without assigning any reasons, the learned single judge has passed erroneous order minutes. Our implementing application is for pending for consideration minutes. 28th is the voting, which is going to place minutes. Kindly a fresh matter minutes.
Finally decided by learned single judge.
Yes, minutes. Decided minutes.
Then where is the question of you are preferring appeal?
Writ appeal minutes. Filed a writ appeal.
You are not impleaded.
Our application was not decided minutes.
Seeking leave to appeal.
Minutes.
You are seeking leave to appeal.
Please minutes. Please minutes. Kindly have it on tomorrow minutes, please. 28th is the counting of election.
Not
Please minutes.
It's not
possible. On 26th minutes. 28 is the counting of votes. They are all disqualified members minutes of the society minutes.
Tomorrow.
Please. Much obliged.
My lord, I am the applicant in this. He is the bank manager. That is the first inquiry has been conducted, my lord. After the completion of first inquiry, the second inquiry has been conducting again, my lord. There is a misconduct of the disciplinary authority, and there is a res judicata, my lord. Hence, there is a urgency of the petition.
No urgency.
My lord, in this
14th of July. No, there is no urgency. Absolutely no urgency. Yes.
My lords,
Yes.
my lords, so suit for rendition of accounts, my lord. In this, High Court had already directed to furnish all documents, but the respondents have not done it. The trial court has not considered the High Court direction, my lords, and has passed an erroneous order, my lords. Kindly be taken up before 4th of June, my lords.
12th of June.
My lords, before 4th, my lords.
It is a writ appeal fresh matter, my lord. So both parties have compromised. There is a rival claim on the our compensation amount. Compromise petition, everything is compromise petition is also filed only for recording compromise for maybe taken tomorrow. Please oblige.
2:30.
Please.
My lord, this matter is covered by judgment of this honorable court in Sumitra versus State of Karnataka and others. We have filed a writ petition for issuance of mandamus to government to restore the reservation for Baljiga and Banjiga community under Article 16 Class 4 in the category of 2A, my lord. Kindly have it on 26 or 28, my lord.
Not possible.
Please, my lord.
Either you wait for regular listing or accept the date which we will give.
A short date, short date.
Date we will give. Decide. The two options are available. Either you wait for regular listing or you accept the date which we will give for posting your matter.
We accept the date.
16th of July. Next.
Lord, my matter was, I had moved it last week, Lord, a writ appeal challenging the eligibility criteria in the tender, which the learned single judge has dismissed. Date was fixed for today, my lord, because earlier date was July. I filed an early hearing application also, but the matter is not listed, my lord. Will it be taken up any?
Today it was fixed.
The date was fixed, my lord. Yes, there is a memo. But earlier date was in July, my lord. I moved the matter last week.
If it is fixed today, then date is listed. If any other date is fixed, then they have to file IA.
No, IA I have filed IA also. Earlier it was fixed for 5th of July. I filed an IA, but the IA was put up late. That is why it is not listed today. It is in the board branch, my lord. That is why any date before the vacation.
Then file IA again.
No, I have already filed.
That date gone. For that IA date is gone. Because IA was listed subsequently, and in the meantime the date is gone.
My lord, yesterday itself I have filed the IA, my lord. IA was not put up with the file. That is why it is not listed today, my lord.
So matter was to be listed today.
Today, yes.
Then get the listed the IA. What is the urgency?
My lord, that is the eligibility criteria I have challenged, my lord. I can't participate in the tender.
After vacation.
My lord, your lordship had considered it, my lord, earlier that is.
Then file IA. Let the IA be posted.
Please.
Lord, we are the applicants.
2nd of July. 2nd of May.
We are the applicant in this case, my lord. We had challenged the acquisition notice by the Muda development, my lord. And the acquisition proceedings final notice was issued in 1994. Till today, they have not taken physical possession, my lord. However, without deciding on that aspect, my lord, single bench has passed an order in favor of Muda. Now the authorities are invading my physical position and possibly taking the position, my lord. I had moved the memo, my lord. Earlier occasion also it had come before this court. But however, the single bench was also assigning in the divisional bench, my lord. Hence it was directed to listed on different bench, my lord. Now, since roster has changed, my lord, the urgency is that they are illegally acquiring the position of the applicants.
After vacation,
My lord, any date before vacation, my lord.
just not possible.
My lord, any date before vacation, my lord. My position will be vacated, my lord, illegally, my lord.
Move the learned vacation, Judge.
Any date before vacation, please, my lord.
It's not possible.
At least a date may be fixed in the first week of after vacation, my lord.
It will be our date. 18th of July. Yes, next.
But any date in,
Don't create urgency when the vacation approaches. Yes.
My lords, one matter, my lords, LB local bodies, my lords.
Which one?
Where, my lords, sixth respondent had put up a construction of 13 floors of a building. My lords, we are the adjacent landowners, my lords, we are the neighbors. My lords, due to the construction cap put up by the respondent, my lords, respondent number 6, my lords, my buildings have been demolished. My lords, it's in a dilapidated condition. My lords, due to the rain, my lords, the entire rainwater is gushing into my property. My lords, learned single judge had directed the, my lords, the respondent number 6 to rebuild that construction within, my lords, with the direction. My lords, till today they have not done so. My lords, hence there is some urgency, my lords, due to the monsoon season, my lords, in the May, my lords, I will be causing difficulty, my lords.
Before vacation, not possible.
My lords, I'll take a chance on 28th or 29th, my lords. My lords, reason is this, my lords, the entire neighboring buildings have been demolished. My lords, it is in a dilapidated condition. We are not able to stay there, my lords.
Move the vacation bench.
My lords, I'll take a chance on 29th or 28th, my lords.
Just not possible.
My lords, because, my lords, I am waiting for 6 months, my lords. From 6 months, I am waiting, my lords.
Then what did you do for 6 months?
My lords, I have moved the matter, my lords.
You should have mentioned earlier. At the 11th hour when the vacation is
Oh, sorry, my lord.
3 days away, then you are
My
mentioning.
lord, I'll take a chance, my lords, on Monday or Tuesday, my lords.
Not possible. Yes, madam.
In this case, matter has been settled. Matter has settled, my lord. Withdraw the-
Settlement.
settle-
Tomorrow at 2:30.
Much-
Yes,
Item number 14, my lord.
14.
Yes, please.
Lord, one matter, my lord.
May kindly be.
Lord,
Immediately after vacation, may kindly be.
At the request of learned advocate Mr. H.N. Basavaraju, the appeal shall be listed on 18th of June.
matter, my lord, the petitioner is, my lord, the urgency is this, my lord, in this
Yes.
petition, my lord.
My lord, I'm for commercial appeal, my lord. My plaint has been dismissed for non-compliance of section 80, my lord. My lord, now,
On compliance of
section 80, my lord.
80.
My lord, now this respondent LLP are negotiating with prospective purchase of this LLP, my lord. So I am facing great hardship by this, my lord. So I have kindly posted on this next week, my lord.
13th of June.
My lord, kindly on 29, 30,
Not possible.
my lord.
Not possible. Lot of matters to be dealt.
My lord, I am facing a lot of difficulty on,
What can be done? Move the learned vacation, Judge.
my lord, kindly, my lord. On-
Move learned vacation, Judge. If you are facing so much difficulty. Courts are not closed. Yes.
Serial number 8. My lord, in this matter, my lord, serial number 8.
Yes.
Contesting respondent itself is not served, my lord.
8.
8, man.
30408.
Yes,
It is a fresh matter, Mr. Kaur.
sixth respondent is not a,
Fresh matter.
no, notice was ordered.
Not, is it so?
After vacation.
Hmm? It's a fresh matter. That is what we told. It's a fresh matter.
One matter, my lord, the petitioner, my lord,
It's a fresh matter.
12th, my lord, December notice was ordered. I have paid the process.
There is no notice. Yes.
52, my lord.
52.
52 and 103, my lord.
Hmm?
Panel council is not giving very much.
52. 52 will go to 2nd July,
And 103 also, my lord.
whom I has requested. And
103, my lord.
103 also, same order.
Same.
3rd July.
39.
103, 3rd July. 1 second. 103, there is no 103. As requested by learned advocate for the appellant, stand over to 3rd July.
Serial number 65, my lord. I appear for the respondent
65 years.
for order. May I request my lord short accommodation to file objections to delay application and stay application filed.
There is a delay of 24 days. So there shall be notice in the delay application returnable on 30th June.
Serial number 34.
Notice already issued. So what do you want? What do you want?
Pray for a short
Time
accommodation.
30th June.
Serial number 34.
Matter, my lord, the petitioner is seeking interim prayer on the stone quarrying license, my lord. My lord, the respondent number 3 has passed the order, my lord. On the basis of the order, my lord, respondent number 6 has started the stone quarrying, my lord, business, my lord. For that reason, my lord, I am seeking interim prayer, my lord. Lordship, may next week, Monday, my lord.
Not possible. It will go to either you wait for regular listing or get the date which we will give.
Lord, Monday, my lord, I am requesting.
That is the only two options. There is no question of any third request. Either you wait for the regular listing or accept the date we give. Decide right now, because many are want to mention. Yes, yes.
This is a fresh matter, my lord, where the prosecution was, my lord, getting time barred. So when the prosecution of the notary was getting time barred, and
Prosecution of?
a notary who had notarized the lease deed, and the accused is an advocate who is a lessee. My lord, we had filed my lord, the directive before the learned single judge. Single judge had directed action. And my lord, the central government is not giving us the report that is filed against the notary, my lord. Only for that short matter, my lord, her prosecution under section 13 would get time barred, my lord. Anytime, my lord.
When the judgment was delivered by learned single.
My lord, the learned single judge had directed them to dispose of the representation in the month of July, my lord.
What you doing?
Thereafter, my lord, we made a representation to them, and my lord, there was no communication, and we filed a contempt 1 month back itself, my lord.
Monday.
It can be taken up, my lord, on
Monday.
I'm grateful.
63, my lord.
Grateful.
63, service is not complete.
It was stated that the service is not complete.
Well, that's,
And that due to be listed next on.
yes.
In the meantime, my lords, I may be permitted to take hand summons, my lords.
Pardon?
In the meantime, I may be permitted to take hand summons.
But you want fresh notice. It is awaited. It is already issued awaited.
And
Service is awaited. Stated that the service to the respondent is awaited. In that view, the present petition shall be listed on 8th July.
Well, that's one
Obliged,
submission.
my lords.
That's serial number 63. my
Serial
lords.
number 79, my lord.
79.
Second set has to be filed. It is ready, my lord. I'll file it in the office, your lordship may grant.
79 is what to be done?
Second set has to be filed.
So 79. 79 to 81. So office objection shall be removed within 4 weeks. Failing with the petition or appeal, whatever it is, shall stand without reference to or order of the court. Similar order in 82, 83. Then 84 to 91. Give 3 weeks and same order.
39.
Yeah.
Item number 39, my lord.
39, yes.
I am for the appellant.
Yes.
Kindly, first week of June may kindly be.
Delay is there.
Delay notice have already been ordered, my lord. They have not filed any objection. 34 delay is there.
19th of June.
Much of it.
Lord, serial number 16, the fresh matter filed by us, my
Serial
lord.
number?
16, my lord, 16, my lord.
One.
Need a short accommodation because there is some development after filing the writ petition. Writ appeal, my lord, I will get attested. First week of June.
19th of June,
Please, my lord.
as requested.
Serial number 41, my lords. I pray for a short accommodation.
Number 19.
90.
19.
19, yes.
Short accommodation. Short accommodation, my lord. Inconvenience, my lord.
Pardon?
Short accommodation, my lord.
You were so fast.
Short accommodation.
You already taken accommodation.
Inconvenience.
17th July as requested by learned advocate.
Of the
Which was the number? 17, 18,
19.
19, all right. 17 July.
Well, that's
34, my lord.
30.
And for the respondent 5 and 6, my lord. I have to file objections.
I have to file objections, my lord. I pay for 34, I have infirmity.
No, no, let it be called out.
Serial number 21, my lord. I am the petitioner.
21.
Serial number 21, my lord. Kindly have it done after vacation.
At the request of learned Mr. Mukkamanappa SP.
Yes.
The appeal shall be listed on 1st July.
Much.
My lord, serial number 63, my lords. Serial number 63 has been adjourned, my lords. There's a connected matter, my lords, on the same subject challenging the same notification. My lords may tag it along and list it, my lords, on whenever date, my lords are given. May give the.
Give the list,
Yes.
this list is along with this.
My lord, serial number.
No, madam, 63 was mentioned. My learned friend was mentioning about 63.
Serial number 41, my lords. I appear for respondent number 3. I pray for a short accommodation, my lords. The arguing counsel is unwell, my lords.
Learned Advocate Satish K. once time on the ground of non-availability of the counsel who is to conduct the appeal in view of the request, as prayed for, stand over to 18th of July.
Much obliged.
Serial number 101, your serial number
101.
Yes, Your Lordship. Any day after vacation, Your Lordship, to secure instructions.
Learned Advocate petition request for time to keep the petition beyond the vacation.
Lots 99.
It is kept at 2:30.
Yes, Your Lordship. We need to secure instructions, Your Lordship. Any day after vacation.
Stand over to 23rd of July. In the regular, not 2:30. Now.
My lord,
Serial number 44, I'm part 4, petitioner counsel is here. I need to secure instructions on the affidavit they have filed. It may be taken up in last week of June, my lord.
Last week of June.
Last week of June.
Stand over to 26th of June. 26. 24 you want.
24th if possible.
24th of June.
26th also okay.
26.
Obliged.
99, my lords. Serial number 99 for the respondents. Pray for short accommodation.
What is it? PIL.
Serial number 99.
At the request of Learned Swarup.
For respondents.
Yes. For what is your good name?
Likit Prakash. For R2 and R.
Petition appellant has no objection.
No objection. I have informed them.
Will or has?
Please.
You have informed or will inform?
Will inform. Will inform.
Then first inform.
Please.
Then give the convey to the court official be adjourned.
Please.
That's I'm sorry, my lords. I understand the issues with regard to section 29E of the Arbitration Act, my lords. The extension has been granted by the commercial court, which does not have the jurisdiction to extend the mandate of an arbitration, my lords, of the tribunal, where the arbitrator has been appointed by the High Court. We have contested on the same point and even on the jurisdiction and the limitation point. Now, my lords, by virtue of the extension, my lords, the arbitration tribunal is sitting and continuing on the day-to-day proceedings. My lords, I'm seeking if it's possible, my lords, next week, my lords, otherwise on the reopening day, my lords.
5th of
Reopening day, my lords.
5th of June.
Content matters, serial number 1, Mr. KP Bhuvan.
Appear for which?
Lords, in this matter,
Serial
we have
number
preferred writ appeal, my lords. Preferred writ appeal. The RP came to be dismissed only on delay, my lords. The matter was not taken up on merits. So therefore, we have filed a writ appeal, my lords, challenging both the orders, my lords.
My lord, single judge passed on orders on 11/12/2023. My lord, before occasion,
Contempt
this
petition came up for consideration. Learned additional government advocate Srimati Pramod stated that the writ appeal is filed in respect of the order brought under contempt. Full stop. In that view, the present contempt petition shall be listed along with the writ appeal on 13th of June. Full stop. Before which date, the appellant.
my lord, let them comply that order subject to result of the writ
All
appeal,
the
my
office
lord.
objections in the writ appeal, failing with the writ appeal stand dismissed automatically.
Pledge.
686 of 25.
Yes.
Serial number 2,
But
Mr.
I
PS
appeal
Nagaraj.
for the complainants. The order at annexure A, page 16, my lord. Operative portion is page 31. Operative portion of the order is page 31.
Notice returnable on 18th June.
Lords, the direction was to consider the representation of the petitioner with regard to release of contract payment within 8 weeks, my lord.
9th June.
The complainant in this case. The Honorable Single Judge Miller, the passed the order as per Annexure B, Miller. The directly accused to Miller, the settle the monetary benefits. The page number 49, Miller, the
9th June.
For the complainant, my lord, have sought for mandamus, wherein this honorable court have been directed to direct the accused to comply with the representation made by me. Same have not been complied. Later on, have made another 2 representation, my lord.
10th June.
Okay.
Number 6, Virupaksha PH.
Paper complaint, madam. Order passed by single and single judgment. Page number 19. Consider to respondent number 4, madam. Tahsildar.
Notice returnable on 10th June.
This is number 7, PA.
Petitioner, my lord, kindly pass on.
Why password?
Senior end up with another court order.
No password after vacation. 10th June. 10 to 10. No password will be possible now in the last days. Yes. If the council has urgency, they should come in the first half.
So number 8.
And this is first court. You can't choose the any other court.
But appearing for the petition.
Yes. Yes, this is a
the
fresh matter.
Matter, my lord, which I submitted, my lord, for else I was under the wrong impression or, my lord, according to me, my lord, on 16/12.
Yes.
16/12, my lord, I paid the process also immediately. I got.
The complex is already built.
Pardon, my lord.
The commercial complex is built.
But it was granted for a park. Now they have constructed a commercial complex.
Already constructed. You are too late.
There are decisions, my lord. Today I'm not ready, my lord.
Notice returnable on 12th June.
Achha.
This is number 9, Srinivas V.
My lord, I appear for petitioner in this case. My lord, this is the second round of petition, Lord. In the first round, your lordship have given a direction for the petitioners to consider to make a representation. Inauguration of Basaveshwara Puttali, my lord, that is idol of the Basaveshwara. My lord, I have given a representation that it should not be installed at the district office, district administration office. Now, my lord, they have planned to inaugurate it on the western side gate of the district administration office, and they have given an endorsement which is at Annexure C. Kannada is at Annexure C, my lord. Typed portion is at page number 46. My lord, may I take your lordships to page number 49, my lord. Now, my lord, they have planned to inaugurate it tomorrow, my lord. This is the English version of the invitation. May I just pass on, my lord. Tomorrow they are planning to inaugurate, my lord, on 25th. They are planning to inaugurate this Basaveshwara Puttali tomorrow, my lord. This is the invitation which they have published today. May I just pass on, my lord.
So they have considered representation or not?
My lord, they have considered the representation. They state that since it was not permitted before the Kannada Bhavan, they are inaugurating near the district administration office on the western side gate.
Where is that?
My lord, your lordship may
When you
kindly
filed
come
the
to page
earlier-
number 49.
When you filed the petition previously, it was at the Kannada Bhavan.
Yes, my lord. Now they are
They have now shifted.
now, no, my lord. Even at that point of time, also it was planned there itself. Therefore, I have given a representation. It should not be inaugurated. Lord, this thing was done near the my lord. The Bhumi Puja was done in a different place. Now they are putting the Basaveshwara Puttali in a different place, 2 different places, my lord. And my lord, when I made the first writ petition, it was not planned to the place where they are planning now, where they are inaugurating. Earlier it was done to be district Rangamandira. Now, my lord, they say that Kannada and Cultural Minister, pursuant to the notification, they are not giving permission. And therefore, they are putting it before the District Administration Office, my lord. Your lordship may kindly see the representation which I have given to them at Annexure B, page number, translated version is page number 27. If your lordship permits, page number 29 is the relevant portion. May I just read, my lord? Upon considering the petition, the Honorable High Court in its order dated 6/12/2024 stated that statue of Sri Baswarna should have been installed in front of District Administration where the foundation stone was previously laid. However, the District Administration has illegally installed it on the western side, right side of it.
What is wrong in it?
My lord, if they inaugurate, my lord, the parking area gets reduced, and my lord, there is a notification which your lordship can kindly come to page number 55. And the Supreme Court have also held in a decision that it should not be put in a public places.
This is public place.
My lord?
This is public place.
Yes, my lord, that's a public place. District Magistrate's office is a public place.
Notice returnable on.
My lord, tomorrow they may inaugurate, my lord. If it is inaugurated, the petition becomes frustrated.
25th of July. This is only a bonus to you.
My lord,
This notice is a bonus.
my lord, tomorrow is the scheduled this thing, my lord. Let there be a till then, my lord, till 25/7, let there be a stay, my lord. If they are able to show that it's not a public place.
We are not here to monitor the erection of statutes, the demolition of statutes. It is entirely their function, unless some statutory things are violated. So shifting of office and shifting of statue and erection of statue and erection of building, there is not a domain of this court.
My lord, in fact, if the my lord, it is contrary to the guidelines of the government also. If your lordship can kindly come to Annexure C, Annexure F, my lord. If your lordship can kindly come, my lord.
Not satisfied with this order? You are not satisfied with this order? Shall next.
This is number 10, PAL.
For the petitioner, my lord, this case, BESCOM has invited tenders for the sale and maintenance of smart meters in the entire Karnataka, my lord. The bid document is at page 54 to 234. The contract, there was a sole bidder and contract was awarded to him. It is at page 235, the contract award, 23/12/2024. Now, the relevant page, your lordship may kindly go to page 240, my lord. 240. The price fixed for single phase meter, smart meter is 4235, and for three phase meter is 7525. Now I have secured the schedule of rates fixed by ESCOM divisions, schedule of rates, my lord. That is at page 256. The relevant page is at 258, serial number 408 and 410.
You are one of the tenderer?
I'm not the tender. I'm public. The prices have been escalated beyond reason, my lord, reasonable. The price fixed for smart meter, single phase meter as per the schedule of rates at page 258, your lordship may kindly see.
The affidavit can be served on the next matter.
What is the stage of the tender process?
No, tender is finalized, man.
Finalized.
Finalized, they have started selling the meters. But the public will have to bear extraordinary cost, my lord. The escalation for single phase meter is 4,235 rupees, while the schedule of rate it is 2461.
Even if you are right, how do we reverse the things?
No, the tender can be stayed, my lord. No, the public money is being fleeced. The escalation is almost 170% in
One
respect of
part of it, if you are right, this is also for public purpose. This
public
seems-
purpose, but my lord, the rate as per their own schedule of rate is 3292. They are selling at 7500. 170% escalation, my lord.
For notice heard, learned advocate. Notice returnable on 17th of June.
17th of June. Seal number 11.
On the last date, Manoj, we had said we'll file the status report. Manoj. Sorry, Manoj, if I handing it over in court because there was lack of paucity of time, Manoj. In fact,
We've received the copy.
What will remain now?
My lords, they've just served the copy. We haven't had the chance
We'll
to.
just look at it. Tell us if anything material, then we'll grant time.
My lords,
Otherwise, your role as a, what was the, who are you? People's Union for Liberties, Karnataka.
this.
Your role is over. Our role is over. Now, their role is over by filing this up.
and we'll continue whatever compliances, Manoj, we'll do it.
My lords, this court may monitor the investigation and the trial as well till the, because. My lords, one more submission, my lords. They were only been directed in the last occasion to comply with the guidelines in PUCL versus State of Maharashtra, paragraph 31(3). But there are other paragraphs also which are relevant.
We'll fully comply with the judgment or any other law which are there. Not only that one, we'll comply with everything. And there's no question of if my learned point, Manoj. We are bound to do it, Manoj.
But the court may keep this case pending so that it might be monitored, or at least, my lords, give us a chance till next week, my lords. We'll make our final submissions. Learned senior counsel is unavailable today. Maybe taken up next week, my lords.
Where is your senior counsel?
He's held up in the Supreme Court, my lords. 1 week, my lords. Next week we'll make our submissions.
'28 at 2:30.
Please, Manoj. 20th of June, Manoj. 28th, please.
Monday.
Please, please.
Please, my lords.
This is number 12, it's a green bench matter.
I appeal for the petitions, my lord. This is regarding the representation that filed before the respond number 1 and 2, my lords. My lords, I am the sale holder considering of the agreement, which is annexed at Annexure D, page number 36. My lord, this representation is filed only to consider the representation of my land. There is a multiple disputes regarding to the ownership of the land is considered, my lords, which my lords can find it at page number 78, dated 26/8/2022.
Page number 78.
Please, my lords.
What is it?
Page number 78 regarding the pending dispute with respect to the scheduled property, my lords. The property is measuring 4 acres, 1.8 gunda in survey number 337. The land was initially given to me under the sale deed dated 7/4/2018. Thereafter, my lord, the same land has been given to the respond number 5 under the sale date. Considering the same, I already filed a civil suit considering for the specific performance and also for the declaration of the sale deed as null and void. My lords, when the thing stood thus, respond number 5 has filed a license for the query list for the respond number 1 and 2. Now, challenging the same, my lords, I had filed a representation asking not to issue the query list in the name of the respondent number 5. My representation can be found in Annexure A, page number 18. My lords, my only contention is that let the contentions be kept open before the respondent number 1 and 2, and my representation may be considered. The contentions which is mentioned with respect to the position of the property may be
What is the
kept open.
controversy? What is the controversy?
My lord, with respect to the land is that the scheduled property was initially given to me under the specific performance with respect to the sale deed dated 7/4/2018, which is at Annexure D, page number 36. Thereafter, my lord, on 23/6/2018, the sale deed was the same was done with the name of respond number 5. This was challenged under the suit of 79 of 2024, which is still pending before the trial court. The suit was filed for specific performance and also for the declaration of the sale deed dated 23/6/2022 as null and void. And also, my lords, with respect to the possession itself, there is a multiple suits that is pending with respect to 30 of 2022. And at this juncture, if at all, if the query lease is granted, with respect to that, the same nature of the property itself will be exhausted.
This mining lease is given to whom? Mining lease is being given to whom?
It has not given to anybody, my lords. Respondent number 5 has filed an application to issue it in his favor.
So what is the problem with him?
My lord, the consideration is that if at all, if it is given in his favor, with respect to the land itself is under dispute. The whole sum of the consideration is that the land is a mining land. And if at all, if the license...
Land is?
The mining land, my lords. The query lease.
The matter, don't talk. You are in the habit of talking the matter. You argue the matter so that we can understand. This is not the place where you talk with the judge. You argue with the court. So the representation is given by you not to grant lease to number 5.
Please, my lords.
Why?
On the consideration that, my lords, there are multiple proceedings that is pending with respect to the ownership of the land is concerned. So until and unless that is settled...
It is your land?
I am holding a sale agreement, my lords.
Original tenant. Now?
Yes, my lords.
Now also your tenant.
Please, my lords.
Then your representation will be considered. Whose suit is pending? Whose suit is pending?
My suit, my lords. The petitioner suit is pending before the petitioner suit is pending before the...
You can seek some relief there also.
Please, my lord. In the meantime, this representation may be considered with respect to the license is considered, my lord.
My lord. My lords, may I seek your lordship's indulgence, my lords? My lords, may I seek your lordship indulgence? My lords, what has transpired is, my lords, the petitioner has filed a suit for specific performance against respond number 5. That is still pending, my lords. What I have sought before the trial court is only on respect of the sale deed. My lords, if the license is granted in favor of the respond number 5, my lords, the suit becomes infructuous, and also the whole purpose of filing the suit also becomes defeated, my lords. My lords, my only prayer before this honorable court is let the representation be considered and any order be passed.
Who is Dipesh Sharma?
My lords?
Who is Dipesh Sharma?
Who's Dipesh Sharma?
Dipesh Sharma is a subsequent mutual agreement holder.
Who has filed the suit? Who is Dipesh Sharma?
Dipesh Sharma is
You don't know.
later on.
This is subsequent purchase. My lords, he is a subsequent purchaser, my lords.
The grievance of the petitioner in this petition as highlighted by learned advocate for the petitioner, Mr. So and so, from the pleadings, comma, is that prior to December 5 has applied for mining lease on the property bearing survey number 337 at measuring 4 acres and 1.5 kuntas at village Tera Kanambi village, Tera Kanambi Hobli, Gunu GUND LUPT Taluka, Chamarajanagar district. The petitioner, क्या लिखा? What did you write? What did you write? हाँ. The petitioner has objection to this and has prayed in this petition to consider representation dated 26/2/24 submitted by the petitioner in this regard to the respondent authorities. Most of the facts in the background paragraph as stated are that Respondent 3 executed general power of attorney in favor of Respondent 5 in respect of the property in question. On 18/7/16. Thereafter, it is stated that Respondent 4, it is stated thereafter that Respondent 4 approached the petitioner to sell the property. Full stop. The petitioner agreed to purchase the same after negotiations. Full stop. A special power of attorney was given by Respondent 4 to Respondent 2 1 Mr. Sharma, who subsequently appears to have cancelled the same. Full stop. Said Sharma then thereafter has filed a civil suit and has obtained ex parte injunction, which was however vacated on 28. The said Sharma initially obtained this ex parte of injunction, which came to be vacated on 28/2/19. The appeal was preferred but was disposed of upon mutual agreement. It is stated by the petitioner that thereafter this sold the property to number 5 on 23/6/2020 in violation of the earlier agreements. The petitioner therefore filed a suit for specific purpose, which is stated to be pending. Full stop. It is stated by the petitioner that he learned that Respondent 3 had applied for co-release. The respondent authorities, it is urged, is required to act to restrain the grant of lease. Full stop. Therefore, the petitioner made a representation dated 26/2/24 seeking cancellation of the request made by Respondent 3 for grant of co-release. Not only that, the subject matter of this petition is involved in the subject matter of the present petition is already being dealt with by the civil courts. 2 suits are filed, one of which is by the petitioner hearing for specific performance in respect to the very property. Full stop. The facts further show that civil rights are involved. Civil rights of the parties are involved in the dispute which emerges from the facts. Full stop. The prayer for paragraph deciding the representation, considering the deciding representation can also not be granted in the aforesaid circumstances, since the petitioner apparently wants to take a leverage for his case and capitalize by filing the present petition seeking directions against the respondent, given to the extent of consider as full stop, respondents full stop. Even the request, even to the extent of consideration of representation, would have its own impact on the civil proceedings. Also, this court is therefore not inclined to pass any order in this petition. The prayers are misconceived, and the petition is misconceived. Petition is dismissed.
This is number 13.
No, I appear for, I will not take before your lordship that I have just received. I only say I have received, my lord, the objections filed by the learned ASG.
Is that?
But now the pleadings are complete in this matter, my lord. In fact, there is in their objection, they do say that the state government has not sent any proposal.
May I pass on the statement of objections on behalf of respondent 9 and 10, my lord?
Kapatguda Wildlife Sanctuary, my lord, which your lordships have on the earlier occasion, my lord, dismissed our petition, if your lordship recalls, confirmed by the Honorable Supreme Court also. Now, my lord, that time it was with regard to the lease which was suspended, which was challenged before your lordship. My lord. Now, the very notification itself was challenged before your lordships, where, my lord, which the committee headed by Justice Kumble, my lord, sportsperson Kumble.
Our statement is ready. My lord, can I pass on?
He is having the lease.
Yes.
He is having the lease.
Yes.
No, here, my lord, one of the significant questions is whether the boundaries could have been altered without a recommendation from the National Wildlife Board in terms of section 26A subsection 3. And our stand now is that we have not received any proposal.
Yes.
26A3 of the Wildlife Protection Act 1972. Lord, my statement is ready. Can I pass on, my lord? My statement is ready. The central government has formulated certain guidelines for submission of proposals to the National Wildlife Board.
There, your lordship, I see para 10 of theirs.
Lord, page 3, para 10, my lord, my submission is that the ministry has not received any proposal. So as such, we have not made any recommendation approving the alteration. So therefore, if there is a proposal for alteration, it cannot be complete without a recommendation from the wildlife.
Your recommendation.
Yes.
I am admitting that we have not sent any
No,
recommendation.
if there is a proposal, it is to.
We have not even received a proposal.
If it is received, then it is your approval is needed.
Yes.
Your
Yes.
approval
Yes.
is needed.
The process is that the state government has to make a proposal to the wildlife board. Then we will consider it and then we'll make the recommendation.
Premature.
No. What now they have done, my lord, is, my lord, may I just make the submission? Earlier, my lord, when we had filed the writ petition, because they had suspended our the lease on the ground that
Today, according to state government, your lease area is within the forest area or boundary within
No.
the.
May I just make this submission? Lord? I'll just make these 2 submissions. The lease, my lord, was suspended on the ground that our thing comes within 1 kilometer of 244 square kilometers, which are being declared as Kapatguda Wildlife Sanctuary. That, my lord, your lordships dismissed our petition, and against which we went to the Honorable Supreme Court. Honorable Supreme Court confirmed your lordship's order. So, my lord, that is completed. Then, my lord, in this petition, what now we have challenged is the 2019 notification. Though, my lord, the Wildlife Board headed by Mr. Kumble, which said that it was 219 which supposed to have been done, that was not done. Unilaterally, they include 244 square kilometers. They make it as that. So if that is not there, my lord, then we do not come under 219, then we will not come within that 1 kilometer at all. That is the reason, my lord, on the last few occasions where the learned ASG appeared, my lord, he said that he will look into it and say whether they have given this approval or not. Because, my lord, under 26, if your lordship just want to see 26A, declaration of area as a sanctuary. So here in this petition, we have challenged that very thing. And now if they have said that They have not done it, my lord, because now my whole thing, my lord, has been suspended in view of that. In the other connected writ appeal, your lordships have, my lord, your lordships will have to hear this matter, my lord, and now the pleadings are complete, my lord, and if
My lord, I have filed my statement of objections. My lord, in my statement of objections at paragraph 12 and 13, my lord, we have relied upon a draft notification that dated 30th September 2024, and we say it is not possible to modify the boundary. Internal page 7, paragraph 12.
They have made it to 300.
Wait, let me
Resolution.
finish.
But then ultimately notification is 440.
as of now, my lord, we have been stopped. We are not doing anything there. So only after your lordships, my lord, if we are able to pursue your lordships, then, my lord, we'll have to seek permission to start again. And then there's one more prayer also, my lord. Another prayer is that there has to be an exit plan. My lord, even the Honorable Supreme Court in Godavarman case with regard to the Sariska Tiger Reserve, there also, my lord, they have said that, my lord, here our entry, my lord, is not illegal. With all the permissions, due permissions, we have come and we have commenced, and we have 20 years license. It is only because they subsequently they declared this. So, my lord, here we have also invested crores of rupees. So many employees are working. If ultimately, my lord, we are not able to pursue the lordships on this particular notification, there has to be some exit plan, my lord, because they can't throw us away. I can understand if our entire lease itself was wrong, and my lord, when it was granted by the government and it was granted by either by mistake or we took advantage and we got it in that land, my lord, then we would not have any case or we will not be able to submit anything before your lordship. But that is not the case. In fact, on 3 occasions, my lord, this honorable court allowed our writ petitions, sent it back to them saying that, and those orders also are there where if they have followed all the things, only if there's any violation under the minor mineral concession rules, then only you can suspend, otherwise it cannot be done. Even though earlier also, my lord, on the ground of 1 kilometer it was done, same thing, contention they had taken, that was done. And then subsequently, my lord, again they did it, we came before your lordships, my lord, dismissed our writ petition. Now that notification, now what happens is this, my lord, because what they have declared and what should have been done, there is a difference. So if our thing does not come in that, if they have not under 26A, my lord, if they have not taken the approval of the wildlife, my lord, then it will not stand, and it will only be to an extent of 219. If it is 219 square kilometers, my lord, then we will not come into that at all. Now, my lord, we have been stopped, my lord, we have not been able to do anything there. So, my lord, my only request, my lord, is now since they have filed this today.
Your only prayer probably is to alter the bond.
No, my lord, not only that. Our other prayer also, my lord, is that they should give us a exit to settle the right of the land. Prayer 2, Roman 2, prayer, if your lordship sees.
Again, in the area comes within 1 kilometer of the wildlife.
Yes, my lord,
That
my
is also
statement
again
is
not
very clear from paragraph
No, my lord.
7.
Now, my lord, may I submit this?
The
My lord,
second
if
prayer-
1 kilometer, my lord, if this is the wildlife sanctuary, my lord, now what the state government has done, yes, my lord, we are within the 1 kilometer, my lord, that we will not dispute before your lordship.
Your second prayer cannot be granted on the face of it.
Beg your pardon?
The second prayer
yes,
cannot be granted on the face of it.
No, my lord, this is.
Lord, may I simplify this part? Under section 18 of the Wildlife Protection Act, the state government can declare a certain area as a sanctuary. That was done by Annexure B. Annexure B, that entire area measuring about 178 square kilometers was declared as a conservation reserve.
Conservation reserve.
There is no difficulty with that, 178 kilometers. In 2019, the state government extends the sanctuary area by adding another 125 square kilometers, by extending it to 301 square kilometers. For that, under section 26A3, they cannot alter or modify the boundary without our recommendation. Now, my lord, if my understanding is the petitioner's claim is the second notification in 2019 does not comply with section 26A subsection 3. Therefore, it is illegal. If it is illegal, then the boundary falls back to the original 178 square kilometers. If it is 178 square kilometers, then I think his operation falls outside the
Outside the
sanctuary
one
area. I
place.
think in my understanding, my lord, that's the case which your lordship will
This is
agree.
a novel argument that has been taken before my lords now. My lord, from paragraph 7 of my statement of objections, my lord, I have clearly stated the reason why, my lord, we are not permitting them to allow quarry within between 1 kilometer to 4.3.
No quarrel with that, my lord. What the learned government advocate is saying, my lord, absolutely no quarrel with that.
Lord,
Lord,
let
as a
them
learned
come up,
ASG
my
said,
lord, with
my lord,
the-
whether they have taken that permission or not, my lord, because if that is not been done,
Here at leisure.
My lord,
my lord,
Here
first week of June, my lord. My lord, no, my lord, my lord, in fact, on the last occasion, my lord, your lordships were supposed to have fixed the date in June. But since they had not filed their objection and they had not made the stand clear, your lordships gave this date. My lord, because we are, my lord, losing, my lord, neither are we getting an exit plan, nor, my lord, we are there. My lord, my lord, now the pleadings are complete, my lord. We will not take more than 15 or 20 minutes in this matter, my lord. Your lordship may hear it in the first week or second week of June, my lord.
19th June.
Please.
Right.
So till then, that interim order may be extended in second matter.
Extend over to 19th
Lord,
interim order.
More submission, your lordship, that
Same
is.
objection.
Which it is operating.
Yeah, we'll adopt the same.
One more submission, your lordship.
Interim order is operating in which matter?
Yes.
Yes,
interim
your
order is
lordships
extended.
only have extended it on the last
Yes,
three
yes.
occasions.
One more submission, your lordship, that. So in spite of stay order, your lordship, that they are not permitted to lift the already crushed mineral.
Oh, my lord.
13.1.
Mineral already crushed, your lordship, that.
To the number.
Lord,
Which is the number? Serial number? Which is the serial number? In 13.1, there is. So interim order granted in writ petition 2609/24 shall stand extended till the next.
my lord, in 13.1, I have filed a statement of objections. 13.1 on behalf of 99 R9 and R10, and we wish to adopt the same one in 13 also in item.
19.
Obligement.
Seal number 15. Writ appeal, Mr. M. Rajshekar.
Being aggrieved by the impugned order at annexure Q notes wherein the assistant commissioner holds my sale deed as null and void for having violated notes the provisions of 79A(b) of the Land Reforms Act and before my lords notes. Notes, I have purchased the notes, the scheduled lands with annexure J notes for a sum of 4 lakhs on 21/9/2015. And my name is mutated in the revenue records as per law lots. Thereafter, based on the application of the third respondent void annexure N, the not second respondent initiates a proceedings against me void annexure Q notes and passes an order saying that I have violated the notes provisions of the Land Reforms Act section 79 and A, B, and note that the sale is null and void. I request my lords to have a look of notes and I have not been served with the notice notes before the inquiry. My humble submission is kindly have a look of annexure P, the order sheet notes, typed copies at page 136 notes. And the impugned order is at Q notes. 137. The typed copy is at 139. My humble submission is notes by virtue of the Amendment Act notes 30/12/2020. The provisions of note 79A, B, and C were repealed, and therefore notes the impugned order is non-est, and it has to be notes interpreted by this honorable court. Learned single judge notes.
Delay of 7 years, and the record shows that you were served. Records produced by the government advocate.
And my humble
Record that you are
submission-
served, and there is a delay of 7 years.
Please notes, my humble submission is notes, there was COVID in between notes, and I have approached immediately thereafter notes.
Twofold reasons, my lords. Impugned order is of the year 21/6/2017. Writ was preferred in the year 2023. And postal acknowledgements were produced before the learned single judge to show that appellant was served, my lords. Para 4, 5, and 6 of the impugned order, my lords. Page 15, my lords.
For a moment, Lords, if my Lords were to look into, Lords, the reasonings assigned by the Assistant Commissioner at page 142, Lords, what he says is that I have not produced the Lords revenue records, I have not furnished the entire land records and Lords genealogical tree, and Lords not furnished the details of the income of the family. Lords, I have produced the income tax assessment records at Lords in Annexure M. At no point of time, Lords, my income exceeded 25 lakhs in a given period prior to Lords 3 years from the date of Lords purchase. That is at Annexure M1 to M2, M4, Lords. And I have purchased this property out of the Lords sale of my agricultural property. Therefore, Lords, it does not fall within the purview of section 79A and B, Lords.
What was your petition?
My lords, this is a buying of land by a non-agriculturalist, my lords. But that's been amended and now merits of the matter was not gone into by the learned single judge. Only on delay and latches, the petition was disallowed, my lords.
Having sold one of the agricultural properties for rupees 3,71,000, I have purchased this property for 4 lakhs Lords. And I have produced those two
Heard learned
documents.
advocate Mr. So and so for the appellant and learned additional government advocate Mr. Navin Chandrasekhar for respondent state and its authorities. The challenge in this writ appeal is that challenge in this appeal is directed against judgment and order dated 24 June 24 of learned single judge whereby the writ petition came to be dismissed. Paragraph. Challenge before learned single judge in the original petition was made to order dated 21/6/17 passed by Respondent 2 Assistant Commissioner, whereby the claim of the petition in respect to the land, subject matter land, was negatived. Full stop. The petitioner had purchased the said land, which was survey number 31/1A2 at Mudigere village, Kaspa Hobli, Kubbi Taluka, Tumkur district, by registered sale deed dated 21/10/2009. Proceedings were initiated by the respondent authorities under section 79 capital A and 79 capital B, as well as read with section 83 of the Karnataka Land Revenue Act 1961 on the ground that the petitioner purchased the said land in violation of the provisions of the Act. Also, the petitioner did not appear in the said proceedings and competent authority passed the order. Paragraph. The challenge paragraph. The challenge to the said order was negatived by learned single judge on the ground that the order was passed on was negatived by learned single judge on the ground that the order impugned before him was passed on 21/6/17, whereas the writ petition was filed after a yawning gap of 6 years, in the year 2024. No explanation, much less satisfactory explanation, has been coming forth for delay of 7 years. 7 years. Full stop. Secondly, the record produced by learned single judge, produced by learned government advocate, additional government advocate before learned single judge, revealed that produced by learned additional government advocate in the nature of 2 postal acknowledgements, before the learned single judge, revealed that the petitioner was served, yet he had whiled away the time, leading to delay and laches of 7 years. Full stop. This court is this court is entirely in agreement with the view taken by learned single judge while dismissing the petition. No case is made out for interference. The appeal is meritless and it is dismissed.
Check sign. 16 is urgent, serial number 17. Is Sumana Naganan?
At the request of learned advocate for the appellant, stand over to July.
Serial number 18.
State appeal.
State
There is
appeal.
delay, my lord, in filing the appeal.
Delay notice returnable on 10th July.
Great.
Serial number 19 is urgent, serial number 20, Mr. Nayak NR. Serial number 20.
This case, my lord, main matter is posted on 29. Writ appeal number 1492/2024. That is the main order has been questioned in that writ petition, my lord. Based on the order passed in that writ petition, my lord, all the writ petitions are allowed by setting aside the orders of Assistant Commissioner and Deputy Commissioner for restoration of land in favor of the petitioner. Now, delay, my lord, delay is not more than 10 to 20 years delay, my lord, they are coming before the court as if they have purchased the site. Because during pendency of the writ appeal, my lord, writ appeal is also dismissed. On that ground, my lord, he has formed the layout during pendency of the writ appeal. Purchase.
So what do you want? What do you want?
And may be have it connected with writ appeal 1492/2024 on 29th. Please.
Next. No order. To be listed on which date? To be listed on 14th of July.
So 21 is urgent, serial number 22, Srimati Vaishali Hegde.
Notice written. There is a delay of notice returnable on the 4th of June, 24th June.
Serial number 23.
Lord, state appeal, my lords, delay of 57 days is there.
Notice returnable on 30th July.
Can we take the notice on the counsel who appears in the writ petition, my lords?
In addition to normal mode of service, it will be open for the appellant to serve the counsel who appeared before learned assembly.
Obliged.
Serial number 24, Mr. K.S. Ponnappa.
Reservation for 6 terms being made only for women in CMC Madikeri. The state was to respond.
In this calendar of events has been issued, my lords, election is scheduled on 28/4. This is a matter, my lords, where reservations are fixed for the entire state for urban local bodies. Elections are held for more than 90% of the, and 3 coordinate benches have upheld the notification. Now, one CMC has come before, my lords.
My lords might only take up page 50, step 4, my lords.
Calendar is issued, my lords. 28/4 is the
Will
election.
admit the appeal and list it for final hearing in on appeal is admitted, having heard learned advocate with the appellant. Shall be listed for final hearing on 28th August.
It's a commercial appeal, serial number 25. Shirish Krishna.
I appeal for the appellant, my lords. My lords, this is a suit for money recovery. My lords, it's a defendant's appeal. The crux of the issue is that, my lords, the plaintiff itself is dissolved entity. And on a wrong premise, the learned trial court goes on to say that it is maintainable. At paragraph 25 of the impugned judgment, my lords, at page 35.
Issue notice returnable on.
My lords, there's execution which is there. They are asking for attachment, which is on 2nd of June, my lords.
Deposit the amount.
My lords, I will deposit.
Full stop. No.
Whatever condition my lords prescribe, my lords, let the execution be started.
100% amount.
My lords,
Money decree.
it is a dissolved firm. My respectful submission is that, my lords. Whatever my lords propose.
Proceed 100%. full amount.
It was a partnership firm which was dissolved, my lords. It's barred by law.
Hard learned advocate so notice returnable on. Delay is there. Then there is no.
There is
question.
one.
Delay of 121.
Yes, madam.
So notice returnable on reopening. 9th of June.
Great.
Seal number 26, Mr. Gauri Shankar S, party in person, PAL.
Gauri Shankar, sir. In the last hearing, started making the arguments. I can continue my arguments, sir. I gave a write-up for your EC reference in the last hearing.
This can wait after vacation. July 28.
Seal number 27, Mr. Govardhan S, PAL.
For petitioner, my lord. For petitioner, my lord. The respondent number 4 is a golf course, my lord. He has encroached a government road and government land, which
Shall also wait 29 July. Yes.
Seal number 28, Mr. Karedi.
For the petitioner, my lord.
This can also wait, no urgency. Some welfare bhavan is there.
My lord, this is the PIL allotment of Cs.
30th July. Yes.
Date, my lord?
30th July.
My lord, any date in June, my lord? My lord, in this,
Not possible.
because construction is already ongoing, there is no stay on
It's
construction.
all useless PIS. You have no
My
time
lord,
to dismiss. They
but
will
there is
dismiss
a-
readily.
There is a prima facie case.
Don't think that we are granting long time because you have a good case. We are granting long time because you have no case. All useless PIs for encroachment, etc. We don't have the time to hear and therefore we are, let it be considered at a leisure when the court has time.
Seal number 29, green bench matter, Mr. Srinivas KN. 29.
Yes,
Lord,
29.
I seek for some time in the matter, my lord. The other side, government has filed a statement of objection, my lord, without serving the copy on me. Kindly direct it. I will arrange to get it served today itself.
Learned additional government advocates, Mr. Hari states that copy of the objections already filed shall be made available to learned advocate to the petitioner within one
During the
week.
course of the day, I'll do it.
Within 1 week, stand over to
Most obliged.
17th July.
Seal number 30, Mr. P. Vittal Shetty.
For petitioner, my lord. This is the respondent number 6 is running a hollow block industry in agricultural land, my lord. The entire area is surrounded by agricultural belt, my lord. He has obtained a conversion for 99 cents of land and established a factory without following the due procedure.
So what is the prayer?
Prayer is for not to grant it.
Not to grant.
For writ of certiorari to direction in the nature of certiorari to quash the impugned order for consent for establishment.
The consent for establishing granted to the board.
The respondent number.
Pollution control. Pollution control board.
Pollution control board, my
So
lord.
they have done their job, examined everything.
Without following the due procedure. my lord.
What procedure?
See, there are number of objections were raised by the villagers.
They are
They have
considered
not,
That,
it is the,
That's what happens is, my lords, when consent for establishment is granted, we only see that, my lords, if legal requirement is complied with it. Now, my lords, the learned counsel made a submission that it's an agricultural land and also says that it's converted. Now, my lords, if it's converted, my lords, it is suitable for operating any industrial area. That is number one. Number two, my lords, as what I saw, I see in the prayer, my lords, they only sought for quashing of CFE. I don't know if even CFO has been granted or it could have been granted by now. This petition, my lords, it's quite old. They've been taking adjournment, my lords. Today it's come up. Let me take instructions, my lords. Let me get a copy of papers. Probably place it before my lords. What is the actual factual position?
Lordship, page number 26. Annexure C1, my lord. As second part, as mentioned in the above reference number 2, the applicant Shri Santosh Pai H has remitted rupees 21.
And board shall file reply.
Yes, sir. Let them serve a copy on his.
Already served, my lord. Copy is already served.
Not served on me
That's
also,
even
my
on the
lord.
government, it's not
Copy is
served.
not
They're
served.
saying served.
The process also paid, my lord. While filing the petition also served copy.
You must serve copy to this.
This, my lord.
So it learned advocate, Mr. So-and-so's petition shall show the copies of the present petition to learned additional government advocate, as well as to the council for the Pollution Control Board, Mr. Mahesh Chaudhary, within 1 week. Puts of reply, if any, shall be filed before the next date, put up on 15th July.
Grateful.
Yes.
So number 31, say PAL, Mr. Ganpati Bhatt.
Therefore, petitioner, madam, senior is held up in another court.
Survey ಮಾಡಲಿಲ್ಲ,
Kindly,
sir.
kindly adjourn the matter. Kindly adjourn the matter, madam.
Why?
Senior is held up in another court, madam.
All right. At the request of learned advocate, you don't conduct the matter.
Madam,
Once matter is filed and the interim order is obtained, you don't conduct the matter.
kindly pass over, madam.
Not possible passover. You are not functioning at your timetable.
Kindly pass over, madam. Senior is held up in another court.
Your Lordships.
Yes, who you are appearing?
I appear, my lord. My lord, it's just the mandamus to consider the, my lord, I'll file my reply, my lord.
You file the reply.
Your Lordship, there is no requirement of any reply. They have in fact complied with 198.3.6 of the direction given by the Supreme Court. So compliance is already done. We are only requesting this honorable court saying under that very paragraph of the guidelines, let the custodian be directed to collect. That's the only request that we have made via a memo that we have filed, Your Lordship.
You are for whom, madam?
The petitioner, Your Lordship, in serial number 33.
No, this is 31.
31 is called, madam.
My apologies.
My lord, the paragraph 28 in the grounds may be seen, my lord. It is for that reason, my lord, I'm seeking for some time.
Your Lordship, in serial number 31, Your Lord. Your Lordship, serial number 31, senior is.
So what is the matter?
Madam, I don't know, madam. Kindly pass over, madam.
You must know when you are seeking time or making request to password. What is the subject matter? What is the subject matter?
Sorry, madam.
What is the subject matter? Learned advocate for the petition who appears even doesn't know the subject matter of the petition, hence interim relief is vacated.
Madam, kindly pass over, madam.
Next. No, pass or not pass.
Number 32, yes, Kalyan Basuraj.
Appearing for the petitioner, my lords.
Stand over to 16th July, as time was paid for. Interim leave granted and will continue to operate till the next. Yes.
My lords, I pray for an adjournment.
What is to be done? This is again PIL.
Yes, my lord.
Yes, my lords.
Argue.
My lords, this being
July 21.
grateful.
Number 33, CPL.
What
I
happened?
appeal.
My lord, I'm
Address.
filing the memo.
Your Lordship, I appeal for the petitioner if the matter may be disposed of because the compliance is already done by the state government.
This is the service board?
My lord?
Service board.
No, my lord,
No.
it is advanced medical
Medical
directives.
We had filed a
When is that?
petition.
Something is filed today?
Yes, I'm filing a memo and I'm clarifying the doubt which they had, my lord, which we have mentioned, my lord, in the notification which I am again producing, my lord, in page 2, notification dated 14/2/2025, my lord, and the doubts is cleared, my lord, in paragraphs 198.3.5 and 198.3.6.
There is no difficulty there, my lords. We are also agreeing to the same thing. We are only requesting an order to be passed by this honorable court for the custodian to follow the directions of the Supreme Court under 3.5 and 3.6. We're not disagreeing with anything that the state is saying, Your Lordships.
The present petition was filed in the nature of public interest petition seeking implementation of the directives issued by the Honorable Supreme Court in common cause into registered society versus Union of India and another 2018 5 SSC 1 as read with modified order, modified judgment dated 24 modified order dated 24/1/2023 in miscellaneous application number 1699 of 19 in the main writ petition. It was contended the right to die with the dignity was integral part of Article 21 and of the Constitution, and that recognizing the said right, the Honorable Supreme Court laid down comprehensive guidelines for the execution and implementation of the medical directives in the field, which included appointment of competent officials to act as custodians. Post of the directions were modified in the aforementioned order dated 24/1/23. Post of. Paragraph. In response to the petition from a learned Respondents state appeared through additional government advocate Srimati Nilofer Akhtar, who filed on 19/2/25 memo producing certain orders of the government and circulars by the government. Issued in compliance of the directives of the Supreme Court in the aforesaid judgment. The documents produced were and 1, 2, 3, 4, 5 continuity here. The said orders and circulars by the government deals with the aspect of compliance and the mechanism for compliance of the directives of the Honorable Supreme Court. It appears that paragraph petitioners had certain reservations that petitioner had reservation that certain aspects have not been taken care of, and that there was a lacuna on part of the government in carrying out the directions of the Supreme Court. Full stop. Negativing the said apprehension and reservation of the petitioner. Today when the petition came up for consideration from a learned additional government advocates, the government produced filed memo dated 23/4/25, negativing and dispelling the apprehensions and reservations of the petition, to submit that all directions, including in paragraphs 198.3.5 and 198.3.6 of the notification dated 14/2/25, are acted upon in consonance with the modified judgment dated 24/1/23 of this Honorable Supreme Court. Paragraph. The memo dated 23/4/25 reads as under. So quote the entire memo. It is here. Full stop. Learned advocate Miss so and so appearing the video conferencing submitted that the petitioner stands satisfied with the steps and measures taken, as well as the orders and circulars issued towards the compliance of the directions of the Supreme Court in so and so supra judgment, common cause in common cause registered society supra. In the aforesaid view, nothing further survives in the present public interest petition is disposed of as not survived. You are also appearing?
I appear for respondent number 3 minutes.
Learned advocate Mr. So and so, Mr. Sanjeev.
SH Prashant minutes. SH Prashant.
Prashant, sorry.
Yes, please.
Appears for BBMP.
Yes, please.
To submit that the BBMC will also carry out the directions of the Supreme Court, for which it may be obliged under the law. Obliged in law.
This is number 34. PAN, Uncle Kote Rajan.
5 and 6, my lords. We have received the copy, my lords, impleading IA.
Petitioner, my lord.
Correspondent 5 and 6, my lords.
Pardon?
We have received the copy of impleading IA. We have received the copy of impleading IA, my lords.
Your
impleading application by the.
In the morning,
No,
I
no,
have
what
served the copy of the application filed for impleading in morning, my lord. They wanted to file an objections to the application, my lord.
At the request of learned of the parties, turned over to 14th August.
Yes.
This is number 35, it's a green bench matter.
My lord, in this, I pray for a short adjournment, my lord. My draft is ready. I just have to finalize it, my lord.
After vacation, 19th of
Lord, the last occasion and the last 4 occasions, this is a seasonal business I have submitted. My working permission will end
My lord, the
in the month
petitioner
of
not
July.
entitled, and I will convince my lord. My lord, my draft is ready, my lord, but some points which I have missed out, I'd like to
No,
incorporate.
it is a very simple matter. Seizure of vehicle.
Saying that the
No.
in June, everything will.
Yeah, everything will end, my lord. And I,
My lord,
and
it's
see, I
ready.
wanted them
I'm
to
doing-
say,
My lord, may
what
I have
is
this
that
on-
I am not possessing while transferring the vehicle?
My
Mineral.
lord, he hasn't paid the amount. My lord, I don't want to argue the matter, my lord, and give him points to counterattack me. I'll file my statement, my lord, and my lord
There
may
is
hear
nothing
this
to
on
be
very
hidden
day, my
here.
lord may hear it. My lord may have it on the 4th. 4th, obliged.
December 36. The
I
writ
appear
appeal,
for the appellant.
B.B.
Lords.
Patil.
Matter may be taken up after vacation. Matter may be taken up after vacation. Lords.
After vacation.
Some personal inconvenience.
Learned advocate, Mr.
I appear for BP Patil.
What is your name?
Sanjay.
Sanjay. Sanjay. Appearing for learned BB party stated and submitted that the appeal may be taken up after vacation. As per his request, 10 over to 4th of August.
Number
Obliged,
37. Mr. Murugesh V. Charity.
For
37.
2 to 7. This is a matter, a small portion of land has been left out, is a island.
Pass over for a moment, my lord.
Pass or not pass? Reopening.
Like
17th
10
June.
minutes, my lord. 10 minutes. Kindly pass over for 10 minutes, my lord.
Pass or is not possible. 17th June. Yes.
Fighting from past 20 years, 4th round of litigation, my lordship.
17th June. Yes.
Date may be fixed.
17th.
December 38. MC Basuraj. December 38. MC Basuraj.
18th of July.
'39 is adjourned. Seal number 40. Mohan.
Very short issue. Your Honor, for the appeal, Your Honor, for serial number 40, Your Honor, serial number, senior counsel Pramona is on his way. Kindly pass over the matter.
Pass
Very
over,
short
yeah, no.
issue, my lord. I'll just say this. I am a power purchase. I have an agreement where, my lord, the name is to be changed. It is changed. The permitted assigns, successors, everybody, my lord, is included in the definition of PPA. For that, they have collected money. And learned single judge says, my lord, you can't collect money. The power purchase agreement provisions itself provide for that.
After vacation.
Sorry.
16th of July.
Appearing on behalf of respondent number 3 and 4, your lordship.
We take up after vacation. After vacation.
Millards, very well.
After.
My learned friend had fairly submitted, Millards, on the last date of hearing that they would not take any coercive action, Millards.
Ready, that way, my lord. I have not filed contempt also. It's a government body, I understand. I have
Immediately
a
after
good
reopening.
case on merits, my lord. I'll contest the case rather than.
Both sides say that, my lord.
The short date, my lord, because there is a very small issue. Not take more than 5 minutes.
Short date you want?
Sorry, my lord.
18th June.
Great.
Whatever.
Deeply obliged.
41 is urgent. Seal number 42. Say commercial appeal. Mr. Leeladhar HP. 42.
For the respondent, my lords.
Dispute between tenant and the respondent. There is no dispute regarding the tenancy. There is no dispute regarding the quantum of rent.
If I may.
So my submission before your lordship is, what? No arrear rent has been paid.
Yes.
My
From initiation.
submission is only this. The appellants filed a execution petition before the lower court. The lower court directed and they submitted the security deposit. We have deposited the keys and the execution petition now stands closed. What is challenged is only the rent arrears and damages. Lordship may post it for hearing.
In the meanwhile, why I am submitting before, as per the direction, you are also deposited 30 lakhs before the trial court. That amount will be paid, kept in abeyance till disposal of this appeal, your lordship. Otherwise, what happened? If I succeed, your lordship, then I will not get the rent because the defendants are from Kerala. So that I want
I'll only take
short
it-
submission, your worship, that's the
Any execution is filed.
execution filed, your
filed by
worship,
them.
30 lakhs rupees I have deposited.
The execution was filed by them.
Filed by them.
It was them that filed it.
I
And
filed the, paid the deposit of also.
have
The
been handed
rent
over.
deposited with the court, 30 lakhs.
So you are the defendant.
Pardon me?
You are the defendant.
Yeah, I am the plaintiff, your worship. I am the plaintiff.
he's the plaintiff.
Then why appeal is filed?
No, he is the plaintiff. He filed because the rent arrears and damages was disallowed by the court.
Appellant is defendant or?
Appellant is the plaintiff, deposited, rent deposit, security deposit which has been given at the time of agreement.
Why you are, how you are agreed by this page 51 order? Advance.
Advance rent.
How you are agreed by page 51 order?
This one, your worship, why, because suppose I succeeded in this appeal, then your worship, the Kerala persons that I can't get it. So that my submission, your worship, only thing.
Your submission all right, but by what way you are agreed by the impugn?
Yes, your worship, because your worship is the honorable court come to a wrong conclusion, your worship, that because of force majeure,
I'll only
force majeure, I will not issue the notice. That has been incorporated, your worship, in page number 37. In page number 37, your worship, turn it to your worship. Para number 23. It is agreed between the parties. Para number 10, your worship, internal page 37. It is agreed by the.
Possession is handed over by you.
I'm sorry, my lords.
Who is in possession?
The possession was with the defendant by virtue of them filing the execution petition and having deposited the security deposit, because the terms of the contract stipulated that unless now the keys have been deposited in court. And the keys have now stands deposited in court. The appellant, admittedly in the main relief also, if I take your lordships to the main relief, is only is at.
No, he is apprehensive about what? What kind of?
1 crore 40 lakhs yours, 60 lakhs yours. Further, your worship, he has filed a review petition before the trial court also. One crore 60 lakhs yours.
The terms of the judgment was, if your lordship sees the terms of the judgment
So
was
this is only about the.
only about the rent arrears and damages, because they're not challenging the fact that the.
Today we issue notice issued or not? No,
I'm for the response. I'm for the response.
Fix of the final year.
One fixed mark. So in the meanwhile, what happened? I have deposited rent advance 30 lakhs in the court below at the time of filing execution petition. That amount will be kept in abeyance till disposal of this. Or otherwise, what will happen? They are Kerala people. If they were vacated, then I will not get
I'll only
money.
make my submission on that. The main relief that is sought by them in their appellant in the appeal that they have filed is they are only challenging the portion of the order relating to the
Deposit.
the rent arrears and damages. They are not challenging the portion of the order which directed them to pay 30 lakh security deposit to the defendant, and consequently for the defendant to hand over said keys. It was on the basis of that.
You have deposited the amount
You deposited yours.
with the executing court.
Yes, sir.
And on their execution petition.
In my execution petition. You are also internal page 51 part of the trial court. Your Honor.
That is the respondent.
The appeal is after hearing learned advocate Mr. So and so, the appellant. Learned advocate so and so respondent. The appeal is fixed for hearing on July 22. Full stop. It was stated by learned petitioner that amount of is 30 lakhs.
Yes, sir.
Has been deposited. with
30
the-
lakhs. 30 lakhs deposited.
20.
30.
So that is what we said. 30 lakhs has been deposited with the executing court, which is in the nature of security deposit.
Yes, Your Honor.
Received
Yes, Your Honor. Rent advance, security deposit.
under the rent agreement.
Yes, sir.
Full stop. Since the appeal is pending consideration before this court, from the said amount shall be invested by the executing court in a fixed deposit, cumulative fixed deposit in a nationalized bank, initially for a period of 3 months and renewable.
Much of
If I may make one submission before your lordships on that, just one submission. If your lordships takes the prayer of their prayer at page number 24, and I'll just take your lordships. This is why I'll make my short submission on that, only on that. At page 24 is the relief that they have sought before this honorable court. The relief that they have sought, if your lordship sees clause A of the relief is, set aside the judgment and decree dated 16/11/2024 passed by the learned additional city civil judges insofar, and I'll emphasize, insofar as rejecting the claim of the plaintiff appellants towards arrears of rent and damages from the defendant as sought claim in the plaint in the ends of justice. This is the only relief.
So on one hand, he has a claim for his damages.
This is the, now if your lordship sees the
against you.
Against me.
And on the other hand, if you are permitted to withdraw the deposit.
I'll take your lordship through the judgment that was passed by the learned lower court, which your lordship will have at internal page number 51. The defendant shall hand over vacant possession of the suit scheduled property to the plaintiff against receipt of the security deposit, amount paid by the.
Will get with interest.
Much of it.
That's all. So therefore, the submission is that if we now hand over the keys.
I know, I'm not seeking hand over.
Because there is a contractual clause which is the substance of the, there is a contractual clause which substance of the argument. The contractual clause says that in the event the plaintiff does not refund the security deposit, the defendant is entitled to hold said suit scheduled premises rent free until such time as the security deposit is remitted. It is on this basis that the lower court came to the conclusion and directed them to take the possession of the premises after paying the security deposit. It's not as my friend says that this is because the contention in the agreement is that I'm entitled to hold the premises rent free if the security deposit is not refunded. And therefore, by them now saying, by now them saying or them arguing that the security deposit may be kept in abeyance tantamounts to modification of a judgment which they have not challenged in appeal.
We are not keeping an abeyance. We're just not permitting you to withdraw. That's all.
Well, the problem is it's already been 4 years and 30 lakhs in 4 years.
LCR may be called for yours.
We'll take up.
LCR may be called. Much of
record shall be called for from the court. Will not first to read before the next date. It is already.
Much of it.
Mr. Pradeep Darak.
Yeah, here for the petitioner and the companion appeal. There are two appeals that are arising out of a Section 9 order. We've completed the pleadings insofar as the compendium of the lower court records have been filed. And we've also filed our written submissions. This will require some substantial hearing because this is a dispute arising out of a CCD agreement, a compulsorily convertible debentures agreement. There are certain defenses that were taken up before the Section 9 court which have not been considered. And I have been directed to furnish my assets and liabilities to a tune of about 1,400 crores.
I'm ready to argue my senior counsel, Mr. Dhyan Chanapa, has briefed in the matter. If the matter may be passed over, I'm ready to address arguments on this.
No, I'm asking for a date to be fixed because I have briefed Mr. Anandkumar. There is some difficulty today.
At the request of learned advocate for the appellant who wants a date to be fixed for hearing, the appeal shall be listed on 29 July.
If I may request a date in June, your lordships. Because my only difficulty is there is an arbitral tribunal that is yet set to be constituted. In fact, it's a 3-member tribunal. 2 members have already been appointed. The 3rd member is slated to be appointed by the end of this month is what they have indicated. But there is a likelihood that this petition itself may become infructuous if it is in July.
The objections can be taken up before the tribunal as well. That's
I understand,
that's
but
the reasoning that's been given by the.
Any date in June, if possible, your lordships.
Not possible.
This is 44 is adjourned. Number 45. K. Krishna.
45, I am appearing for the respondent.
If I appear for the metro rail, my lords, this is the matter I mentioned.
number 9,
This is the matter I mentioned the other day.
There is no system before this court of holding the hands. You hold your hands only before the God. We are not the God. So don't be over indulgent in showing your courtesies, right? Be a upright lawyer. We don't want your hands folded before us. Yes. Yes, Mr.
Proposed respondent number 9.
Appear for the appellant, my lords, in writ appeal 891. The lordships may recollect, this is the
There is a
matter.
practice of holding hands before the judges in this high court, not before this court.
I'm sorry.
Yes. At least I don't like it.
I'm sorry.
You are holding hand before the judges. Yes, Mr.
Yes, my lords, this is for the, I appear for the Metro Rail Corporation, my lords. This is the matter regarding that airport line where, my lords, your lordships has observed that possession was handed over to us, of course, subject to further consideration of the writ appeal, because the learned counsel for the respondent said.
That compensation.
Correct, my lords. Now,
Advocate
yes, my lords, now the issue therein, my lords, is they're obstructing us from doing the work. If that clarification is done, that of course we are bound by whatever your lordship directs. If your lordship so directs at the end of the day that we have to give a higher compensation, we are bound by what your lordship says. But let them not obstruct the work, my lords, because possession, yes, is handed over. But on instructions I'm submitting, in fact, we've also placed an affidavit that they're not permitting us to do the metro work, and we are also bound by a by timelines, my lords, where that airport line has to be constructed.
May I
In fact, we're one of the few cities which are not connected to the airport at all through metro.
May I make my submission? Well, this land came to be acquired by issue of a notification in 2002 and 2004, and the award was not passed. So the learned single judge has held that the entire proceeding has lapsed and has been abandoned. While hearing the matter before the learned single judge, BMRCL said that a portion of the land is required for this metro train, for which we agreed. But the condition was that whenever they are taking possession, they should give us the value of which we prevail.
Compensation
As per the adjoining landowner, there is a discrepancy, but we have
We are
reasons for it,
asking
but that
for-
has to be worked out before the appropriate forum. Of course, we are in your lordship's
My
hand. If your
submission
lordship so
is-
direct. My
my
limited
submission
prayer
is-
today is let them not obstruct the work.
The senior counsel submitting on behalf of us.
Blood-
Senior counsel is submitting on behalf of us. On behalf of respondent number 1 and 2, the senior counsel is on video conference.
Blood, may I
Just
submit?
one last before Mr. Harnally commences, just one last submission. On the last, in fact, on 24th of January, it was noted that it was stated that the possession is already handed over. We welcome that, my lords. But now what's happening is, my lords, they are obstructing us from doing the work. We have placed that on affidavit. If, my lords, they could undertake that, yes, subject to outcome of the writ appeal, let them not obstruct us from doing the work. We are bound by, we are in your lordship's hands. If your lordship so directs that we have to give a higher compensation, of course we have to work it out. But if the work is stalled, my lords, then it's only this small portion.
My lord, this is
It is the work of laying the metro railway.
Yes, mas metro rail, which connects, my lords, from, if your lordship should have seen, from Hebal flyover, it comes along the ring road and it has to connect towards the airport. Now, this is the land, my lords, right next to that Hebal flyover, which this land is vital, my lords, to connect parts of North Bangalore all the way to the, in fact, North Bangalore will connect all the way, all of Bangalore will connect to the airport. Now, because of this land, my lords, we're not able.
Will the dispute about the extent of
No, the dispute, my lords, in fact, the learned single judge, as Mr. Harnally rightly submitted, quashed the acquisition.
who will decide now?
The compensation amount, my lords. My lords, the undertaking before the learned single judge, I would respectfully submit, was that the package compensation offered would be accepted. Now they want a higher rate. Be that as it may. In fact, I have a preliminary objection to that, but that can be heard at a subsequent stage. Our only,
Competent forum for determining.
yes, my lords, they'll have to determine it over there.
We have, may I submit? We have no difficulty in agitating the matter before a competent forum. But the point here is, we have voluntarily agreed to hand over this land without there being an acquisition. What I submit is, let them determine the value as on the date of taking possession of the property. Whatever is the value, let them give. No, if I am aggrieved by that, then I will go
You
to
are
the
not
court.
without
Now they are-
compensation,
What
isn't
they
it?
are now
You've
saying is,
deposited with KIDB, and in fact,
What?
KIDB has issued them a notice to come and collect it. They don't want to
what?
collect it.
No, no, they are now determining the compensation as on 2002 and 2004.
2000,
Let them
no, that
determine
also
the
is wrong.
compensation
It's not correct.
whenever
2020 rate.
hand over the land to them.
Partition and separate possession in the honorable trial court pending, my lord.
The only point which I am
There is
asking
there
is,
senior counsel not instructed. The
In
compensation was computed as per 2020 rate at 12.1 crores per acre.
very well,
Now,
that amount may be paid with giving liberty for me
yeah,
to
that
agitate
is
the matter
precisely
before
what
this
we are
common
saying.
court.
If 12.1 crores malos were to be considered square meter rate, it works
As
out
on
about
the-
approximately 30,000 per square meter.
My
That
only
way,
point is, well, let them determine the value as on
Which would be the competent forum for them to approach?
if now since the acquisition is quashed, we can't pass an award. If an award is passed and they are aggrieved by it, then they'll have to approach the concerned civil court. But now, of course, I understand their difficulty. We can't, as in not we, the KIDB cannot pass an award because as of now, the acquisition stands quashed. If they pass any award, it will be in contempt of the court's order. So we're in this difficult situation.
Case is pending.
let them treat it as a land acquired by consent, determining the value as on 2024.
KIDB.
Then nothing remains. So you are saying that you will abide by the order which may be passed by the court regarding compensation.
Yes, Maharaj, of course. We're in your lordship's hands.
They are saying, you are saying.
Yeah, in fact, they were the ones who made the offer that they will accept the package compensation. Now they are resiling, but be that as it may.
I didn't say anything about package compensation.
Single
I
judgment.
only-
If I may give a solution till the matter is heard, Manoj, after vacation, there's around 12.5 crores.
No, but you are not paying me compensation also, you want to do the work.
But by evening, I'll pay if my learned friend is agreed to take it.
No,
I'll
no,
give it by today.
AG has not done anything. Last time you made an offer that he will try to mediate.
Not mediate, Manoj. The first installment of 12 crores, I will pay immediately, Manoj. My learned senior friend.
Could my lords kindly see para 6 of the order dated 24th January, my lords? So what your lordships have observed, that the learned advocate general submitted the package.
There are different parcels of land acquired. There are different.
Yes, man, several parcels of land, several
The
parcels.
highest rate of compensation.
What they now want is what was given to the neighboring land. There's another portion of land.
What
and
is the difference of that and you are offering?
There is, my lords, about per square meter, about 50 to 60,000 per square meter.
No, man.
Because this abuts
This is,
this
I'm sorry.
abuts the main road.
Sorry,
There are,
You
It's
can
a
strike
one square
You can
feet.
strike a balance and we'll pursue it.
Sorry.
My lord, this is separate suit for partition and separate possession in the honorable trial court pending, my lord. In OS number 1176 of 2019.
That's a different issue. If he wants to take an order, let him take an order in civil court. There is no
I
order.
find the necessary applications.
He wants his share over here.
So we'll say that they will abide by they will file undertaking.
Yes, Madam.
And let them continue with the metro.
Yes, let them not obstruct the work, and
So
your lordships may
your-
give a
your,
date.
No
Your
compensation
concern
is
only is
paid.
about compensation, not, there is no challenge to the acquisition.
No, Madam.
No
KIDB
challenge
has
to-
challenged the learned single judge's order insofar as the acquisition being quashed. We have also filed an appeal. KIDB is the acquiring authority. KIDB will then hands over the land to us.
They
EG
can,
appears-
my lord, they can by virtue of an agreement take over the land because there is no acquisition as such, no award as such. So it would be better that if they take over the land by virtue of an agreement, by a consent agreement, which they are doing in other cases.
Still you want to apply, mind about the
But
striking.
we'll do that, but let them not obstruct the work because we are bound by certain timelines. The 50% are central government funds. Now those funds, if they lapse, that's another issue.
Last time we have said that we have handed over possession. If my
Well,
client is
obstruct ಮಾಡಲ್ಲ ಅಂತಂದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ. I'm so sorry.
ಅಲ್ಲ ಹ್ಯಾಂಡೆಡ್ ಓವರ್ ಪೊಸಿಷನ್ ಅಂತ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. ಅವ್ನು ಮಾಡಿದ್ರೆ ನೀವು ಪೊಲೀಸ್ನವ್ರು ಕರೆದು ಆಚೆ ಹಾಕಿ ಅಷ್ಟೇ.
Then can I just suggest this, Madam? Since Mr. Harnelli is now reiterating that possession is handed
No,
over,
so
my lords may
far as
reiterate
there
that,
is
and
any
then post a date.
difficulty-
We'll argue the matter.
If there is any obstruction, let them get in touch with me. I will tell them.
Learned single judge just quashed the acquisition on the ground that award was not
My
passed.
lord, Mr. Harnelli fairly submitted, my lord, saying that he'll sort
Now
out the
that
issue.
there is
So-
no challenge to that.
There is a challenge. There is a challenge to the learned single judge's order. While disposing of the writ petition, the learned single judge
Challenged by you
and KIDB.
and KIDB.
Yes, and KIDB.
Now as far the claimants are concerned,
Yes,
they are only interested in compensation.
in compensation.
Correct.
So if they agree to a particular figure or rate, all appeals can be disposed of.
Possibly, at
Yes,
least ours.
absolutely.
KIDB may have a larger extent. I'm not sure about. I can't speak.
My
for
lord, if
KIDB.
your lordships, one suggestion, can I make one suggestion, my lord?
Yes.
My lord, insofar as there's around 12 crores and odd which is already deposited, will permit the landowners to collect the same. The differential amount, my lord, we'll try and see if possible, my lord, consensus can be arrived with between Metro, KDB and the landowner, my lord. So we'll release the initial amount of 12 crores insofar as the landowners are concerned.
3
We'll
crore
have a
49. 3 crore 49 to the land losers. That is
Sorry,
their.
I stand corrected.
12 crore per acre. Their extent is 3 crore 49.
I'm sorry, 3 crore, the proportionate amount, we will give it to the landowner. Balance amount, my lord, we'll see if we can, a consensus can be arrived at, so that we can give the quietus to the litigation.
That can be done, my lord, without prejudice to our right.
Without prejudice, without prejudice.
Absolutely.
Without prejudice, my lord. So that by,
That is disputed by the land. Pending final determination. In the meantime, that is also good.
That can be worked out.
well, it can be worked out. I'm just giving a solution to the problem, my lord.
Yes, Madam. We welcome the learned advocate general suggestion and.
Yeah,
the
that
appellants-
solution is acceptable to us also.
And your lordship also fix a date for the parties to meet, my lord, so that any
Monday
date-
will pass.
Monday.
Monday will pass the order. How to just
Please.
how to organize the order.
Grateful, Madam.
Very
Please.
well. Okay.
Today we deposited how much? 15.5.
3.49 is already, in fact, if I'm not subject to correction by the learned advocate general, 3.49 crores they were asked to collect, but they don't want to collect right now.
No.
No, it's not paid to us, not deposited.
Notice
Anyway,
was
we will
issued.
talk, we'll discuss among ourselves and sort it out and get back, my lord. If paid, why not paid and things like that.
Monday, Madam. Grateful.
Seal number 46, Mr. Ranganath S. Joyce.
Client's
46.
affidavit has been filed, my lords. Our direction was to revisit the pension. We have fixed the pension at a higher level, my lords.
10th July.
Number 47, Mr. S.V. Bhatt.
For the company.
KIDB is the answering respondent.
Yes.
Pardon?
KIDB is the
KIDB is the
answering
answering.
respondent.
Where is he? Quebec?
The 2003, 2004 acquisition, my lord, we are not able to get the compensation.
Quebec, somebody may appear.
A date may be given, earliest
On
date.
date, then 11th June.
Number 48, Mr.
11th,
Keshav.
6. Date.
48, who is there?
And for the compliance, they want to comply with the orders.
I am for the fourth accused.
They have to comply with the orders of this.
Fourth accused. I seek short accommodation because the director is only the in charge director. Only financial liabilities are there.
They have withheld my non-practicing allowance, my lords.
Time, please. 18th June.
Number 49.
My lords,
Yeah, Anupurna
going for
Bodolai.
petitioner, the second round of contempt, my lords. In
My
the
lords,
first contempt petition.
There is a
my lords,
virginal side appeal filed by the state, my lords. Request for the contempt to be connected along with the same, my lords.
My lords,
OSA 20 of 2024, my lords.
Why?
It's a virginal side appeal, 20 of 24, my lords.
sir, one submission, my lords. if
It
I-
was stated by learned advocate, Government Mr. Navin Chandra Shekhar that original child appeal is filed in respect of very judgment and order. In that view, stand over to 20th June.
This is number 50. S.C. Sundaresh.
In this case, the complaints report has not been
For
filed.
the accused in this case, my lord. It's under process, my lord. Kindly grant 2 weeks. Immediately after vacation, we will file a complaint affidavit, my lord.
18th of July, as requested.
This is number 51. Mr. Saravana S. 51.
July 23.
Fifty-two is urgent. This is number 53, Mr. Sachin B.S. 53.
So I appear for the complainant.
Minutes, we have filed wakalat for the accused today, minutes. The Balakrishna Shastri has filed wakalat for the accused.
Wakalat now is filed all. Then go to 4th of July.
Name ಬರ್ಕೊಡಿ sir.
Number 54.
I appear for the
Vijay Kumar
complainant,
K.
my lord. Complaints of the order, BDA has executed, instead of executing 7 sale deeds, they have executed 2 sale deeds. In spite of lapse of 2 months, and they have to execute another 5 sites. Though they have given me allotment letters on the previous date of hearing, they have not executed the sale deeds in my favor.
My lord, we have already executed, we have signed the sale deed and handed it over to the petitioner. They have to pay the stamp duty and get the registration done. They are refusing to do it, my lord, saying that we have to pay the stamp duty and the registration.
My instruction is that they have not handed over this document to me.
My copies have been placed for your lordship's consideration. Originals have been handed over to the petitioner, my lord. Sorry, my lord, I have not translated it. There are 5 sale deeds, my lord, including the letter exempting the appearance of the officer, my lord, has been issued. And my lord, we have signed it in the bottom. The complainant has also signed it in the bottom, my lord. Now he has to pay this, remit the stamp duty, my lord, on the Kaveri portal and get this, get an appointment for registration of the sale deed, my lord. On that appointed day, we will go and sign, get the registration done. Now, my lord, the stamp duty has to be paid by the complainant, my lord, to the Kaveri portal. Without that being done, my lord, registration process will not go through. We have signed it on 29 March 2025 itself. We have signed it and handed over
I
the
will seek
originals.
instructions, madam. I was informed that they have not handed over this document to me. I will show this and I will seek instructions.
My lord, the direction, my lord, of the learned single judge, my lord, was to execute and register the sale deeds, my lord. We have handed it over the documents, my lord, to the complainant. For registration is a process, my lord, the complainant can do, my lord.
So what is the breach?
To one day time may be granted, my lord. I will seek instruction and make submission.
What is the breach? What is the breach of the order?
The previous two sale deeds, they themselves presented the document and got it registered.
Where is that order? Which
For-
is breached? Which order is breached?
1 minute. The order dated
Read it.
14 September 23, my lord.
Read it. Page.
In page number 16, in view of the matter, petitions are disposed of, directing the petitioner to deposit a balance amount of 2,520 rupees and 5,31,216 rupees within 2 weeks from the date of receipt of certified copy of this order. On the receipt of amount, respondent BDA shall execute and register deed of sale conveying said sites if they are available as sought for by the petitioner in this petition, and if not available, the respondent BDA shall identify and allot suitable sites and complete the process within an outer limit of 8 weeks from the date of balance amount paid by the petitioner.
So when you are going to?
And order dated 22/1/25 may kindly be seen, madam.
You received. You received this?
Today I have received it, madam. Now in the open court.
The original has been handed over to the complainant in the BD office, my lord. He has also signed it.
I have no instructions regarding that, my lord. I pray for a time.
To do the necessary formalities completed at your end.
We are ready, my lords. They have to.
Seal number 55. The Navya Sri R. Rao, party in person.
My lord, this petition I have filed against the Department of Horticulture, accused number 1 and 2, who have intentionally violated and not obeyed the order passed by the single bench, my lord. My lord, my prayer before the single bench is to conduct an department inquiry where the accused of the Department of Horticulture who reports for accused number 1 and 2 have violated KCSR rules, my lord. Annexure A, page number 25, I mentioned what are the KCSR rule the employee has been violated, my lord.
Yes.
On 20th of August 2024, we have issued the endorsement to the party in person, my lords, complainant.
My lord, they have issued me the endorsement stating that it is your personal issue and no action can be taken accordingly, my lord. My lord, after arguing a single bench where I have clearly showed that what are the cases are rule has been violated, my lord. My lord, this matter has been even while arguing 482 petition, the single bench of the Supreme Court, Mr. C.T. Ravikumar sir have said that it is a violation of KCSR rule and filed WP before the Karnataka state bench for my lord for me. Later only I filed the writ petition.
Page 16, my lords, page 16, para 6, my lords. We have to consider the representation of the complainant herein, which we have done on 28/2024. We have given the reply to the representation as such, my lords. Now, if they are aggrieved, they have to challenge the endorsement what we have given.
So then disposed of, giving liberty to you to challenge the endorsement.
This one.
Seal number 56, Mr. Basuraj Patel, GK.
There is a positive compliance, my lords. Compliance report is also on record. There is a positive compliance of the directions of the learned singer.
Nobody is keep back.
Sometimes if there is a positive compliance, people don't appear.
They will not appear. We'll wait till 2.
Very much.
Serial number
56.
56.
Seal number 57, Mr. Shiv Prasad Shantanagowda.
My lords, I appear for the complainant, my lords. My lords, there is police report awaiting in respect of accused number 1, my lords. This may be taken up after vacation.
4th July, as requested. Send over to 4th July.
Seal number 58, Mr. Siddharth Suman. Petition PAL.
I appear for the petitioner, my lords.
My lord, as per the directions of this honorable court dated 24th November 2021, my lord, I am filing the report, my lord, of the revenue authorities who have inspected the spot.
Sir.
Give copy.
My lord. Petitioners come, sir.
I am for R4.
Yeah?
R4.
No, petitioner give for it. My lord, petitioners contend that there is an encroachment of 1,918 square feet. My lord, but the officials here, my lord, on inspection, find that there is encroachment of 572 square feet.
I'll have a look at the report. It might be posted after vacation.
I may be permitted to rectify the office objection in office.
8th July.
Number 59. Nagarajappa.
Petitioner, my lord. That's an encroachment, my lord, on the, my lord, the Sarkari tank, water tank by the contesting respondents.
Lake,
Lake, man.
it can wait. 9th July.
I make a submission, my lord. We can't file a better one, my lord, for respondent number 2. I filed wakalat, my lord. Office has raised objection. I may be permitted to withdraw and file a fresh wakalat for respondent number 2, my lord.
We approach the. Yes, next.
Seal number 6.
Permitted wherever you want.
Madam.
December 2024, my lord. They have to file a status report of making a survey of the stormwater drains, my lord, in Kotte Gram Panchayat. Still now, they are not made a
I will.
date may be fixed. My lord.
Date
Achha.
after 1st July, any date.
62. Mr. Viresh K.
Awaiting service of notice, my lords, in respect of.
Service is awaited, shall give some date.
Date may be fixed, my lords.
Number 63 is adjourned. Number 64. Mr. Anirudhanand.
Whatever date is given, just write, stand out. Yes.
For the appellants, my lords, I may be permitted to take substitute service on respondent number R3B, R3C 1 to 3, R8A, and R810B, my lords.
66. Necessary steps shall be taken
I have to take, my lords. For substitute service, I have to take now, my lords.
by law and for the appellant. Shall- Next.
Number 65 is adjourned. Number 66. Sumana Naganan.
Sir, the copy upon respondents appearing in the writ petition, my lords. We will file a memo to that effect in the register, my lords.
Service is awaited, stand out.
And awaiting notice to respondents.
9 July.
Obliged.
Number 67. So, Mr. Venkatesh S. Sarabati.
Appear for the petitioner. There is an office objection. I will comply. I'll comply to 2-3 days. Time may be good.
All office will be complied with within 3 weeks. Registered on 18th of June.
Number 68. Mr. Narayan Swamy KB. Mr. Narayan Swamy KB.
I seek 3 weeks time to comply office objections. 3 weeks time I seek to comply with office objections.
3 weeks.
Number 69. So furnishing of process fee, etc. for issue of notice. 69.
69 to 78. Individual orders. Time is granted to take steps. By the learn apparent, whatever.
79 to
71.
91.
I appear with the respondent in 71. There is an interim order operating. Kindly fix a short date for final hearing.
In serial number 71, my lord, the respondent number 3 died, my lord. I am reporting the death of the
Request
respondent.
book 73.
71 and 72. Both are.
No, 71 and 71.1, my lord. Point 1.
Read petition 26959 of 2024.
This serial number 71, my lord, respondent number 3 died, my lord. I am reporting the death of the respondent number 3, my lord.
71 is a government appeal, my lords. Afraid time to take steps regarding.
And 71.1, my lord, respondent number 16 is the respondent number 3 in the first appeal. Is died. One Mayana is died. I am reporting death of the just Mayan. And I'll take steps to bring his LRs.
Orders passed.
Copy, please.
So this thing is awaited till June 23rd, put up on June 25.
Reporting that. Mayana died. the first appeal, third respondent, in second appeal, 16th respondent. I will bring the necessary legal aids. And my lord, insofar as acceptance notice, my lord, the dishonorable court directed to serve the notice to the advocate who appears before the single judge, my lord. I served the copy, my lord, respondent number 5, who we are Vishwanath, my lord, advocate. I served the copy to him personally. Accept notice. And insofar as respondent number 8, my lord, I served the notice to the advocate, the senior advocate, Prasanna Kumar.
79 to 91 are urgent.
My lords.
Number
Kind
92.
permission, my lord. 70. My lord, 77.
My lord, serial number
77.
82, my lord. Serial
There
number
is some urgency
82.
for this reason, my lord.
Second matter, my lord, serial number 82.1.
77, my lord. There is some urgency for this reason, my lord. Then a single judge has passed an order to release the remaining 30% of the sites, my lords, by setting aside the notification issued by the government. My lords, now government is in appeal. My lord, the respondent number 3 was the town planning authority. The direction is for the town planning authority, my lord. Now, my lords, what has happened by virtue of this, my lords, writ appeal? The authorities are not releasing the 30% of the sites. My lords, order is passed in the month of November, my lords, September, my lords, 2024. My lords, in September 2024 is the order. My lords, there was a direction to be complied within, my lords, within a period of 4 weeks. My lords, till today, my lords, the order has not been complied. My lords, order has not been complied. My lords, in view of this, my lords, I am not able to execute the sale deeds in respect of the sites, my lords, who charged to be released in favor of the respondent here, my lords. My lords, there is some urgency, my lords. My lords, I am ready to deposit 50% of the demand, my lords. What is?
After recess.
My lords.
After recess.
2:30, my lord.
My lord,
Submission, my
serial
lord.
number
31, my lord. My colleague has sought, my lord, passed over. But your lords vacated the interim order, my lord.
Not vacated.
Not.
73, serial number 82, my lord. 82.1.
Just see, you just see the actual order, not what I said.
73. My lord, serial number 82. My lord, serial number 82.1, my lord. There is 2 objections, my lord. I have paid the court fee, my lord. The office objection may be overruled. And my lord, the AGA, my lord, permitted to take notice for 1 to 3. And my lord, issue notice to respond number 4, my lord.
Which one?
82.1, my lord. Connected matter.
That has been adjourned by my lord by 3 weeks to comply with the office objection.
My lord, I have complied all the office objection, my lord. I paid the court fee also, my lord. Only, my lord, the office is raised the objection. So far as, my lord, page number 67 is concerned, it may be typed copy, my lord. Because it is the sketch, my lord. Therefore, my lord, I am unable to file a translated copy. It may be overruled, my lord. Page number 67, it is the sketch, my lord.
82.1, read petition number 31804 of 24. Pending examination of the compliance of the office objection, there shall be notice.
My lord, serial number 92, my lord.
Returnable on 92.
Contempt matter. Notice may be issued, my lord.
Notice.
73, my lord.
20th of June.
Much obliged.
75, my lord. Serial number 74, my lord. And for the appellant, my lord. My lord, the respondent number 1 has initiated.
Yes.
Serial number 96.
Yes.
Final hearing matter.
Yes.
85 my lords, serial number 85 my lords, there are 3 objections my lords, kindly pray for 2 weeks time my lords.
Time will be granted. Yes, Mr.
76, my lord. 96 may kindly be after vacation.
73, my lord. 73.
74, my lord, and for the appellant, my lords. My lord, the respondent number 1 has already initiated contempt proceedings in case 80, my lords, against me. Stay has to be granted, my lords. So hence, if the matter may be heard, my lords, I do.
Might reach also. Yes.
73.
Lords, that is
Might
70.
reach also.
Please.
77, my lords, afternoon. 77, my lords.
After
73, my lord. Government
afternoon, my lord.
73, government has filed appeal, my lord. Copy has not been served till today. Matter is urgency, my lord. Petitioner counsel is only 80 years, my lord, senior citizen. Only short point is involving. Only short point means to 2 are citizen. Only short point is involving. Only short point means to 2 are endorsement is issued. That as the endorsement is challenged.
12th June.
Copy.
Serial number 87.
Copy will be.
87, Lordship, I pray for short accommodation.
Lord, 77 afternoon.
After
Malord.
vacation.
2:30.
70.